Many employees ask if an employer can fire them for being sick, and the answer is it depends. An employer can't terminate you specifically because you just disclose that you have a medical condition or a disability, or you're taking your sick time off. But an employer can or may be able to terminate an employee if they have excessive absentee or they've exceeded those sick days that they have by law, and now they're still calling in sick. There may be some grounds for termination, but it's important to talk to an employment law attorney to assess the facts and what took place to see whether or not it's illegal or not. It's really scary for an employee who is going through a serious medical crisis or condition or has a disability, and now their job is on the line. That's scary and traumatic because not only are they trying to get better or get the medical attention and treatment that they need, but now they're worried about money and their financial condition and being able to go to work. And so when those two intertwine, it's exhausting and it could worsen medical conditions. And so it's really important to find help and an advocate if you feel like you're in that situation where your medical condition or disability is now an issue with your work and your job is threatening your employment because of that medical condition or disability. FMLA is a federal law that allows employees to take protected leave. However, the employer must have 50 or more employees. In California, we also have CFRA, California Family Rights Act, and the employer must have 5 or more employees, and that would entitle an employee to 12 weeks of protected leave for a serious medical condition. We often hear employers say that an employee has exhausted their protected leave. And what that means is that the employee went out on a 12-week protected leave for a serious medical condition for either themselves or an immediate family member. And then once that 12 weeks is up, they're no longer protected. However, under the ADA or the Fair Employment and Housing Act, they still may be protected under anti-discrimination laws that prevent an employer from discriminating against an employee if they require more leave than that additional 12 weeks of protected leave. They're still protected under anti-discrimination laws. That's where the ADA and the FEHA come into play with discrimination lawsuits. There are situations when an employer can legally let somebody go if they've been out on an extended leave for a very extended period of time, and based on business necessity, that employer needs to replace that employee and put somebody into that position. If they provided the reasonable accommodations, they've engaged in the interactive process, and now it's a hardship to keep that position open, the employer may be authorized to fill that position, and it would be a legal act. At-will employment in California means an employer can terminate an employee with or without cause. However, that does not mean an employer can terminate an employee for disclosing a serious medical condition or a physical or mental disability. Even if an employee is in the probationary period, they just started work and they're still within like the 30 to 90 days of probationary period, if the employer terminates that employee for being sick or disclosing a medical condition or pregnancy, it could still be actionable as a discrimination case. Red flags in a discrimination case regarding an employee disclosing a medical condition or disability would be that the treatment toward them instantly changes right after they disclose their medical condition or physical or mental disability. Their job duties are strict. Someone else is now doing what they used to. They're excluded from meetings. They're being excessively scrutinized or written up, or they're just being ignored and dismissed in the workplace. Or the HR simply doesn't engage them in an interactive process and just leaves them on an extended leave of absence indefinitely. Those are all red flags signaling that the employer may discriminate against the employee. Documentation that's very important for an employee if they feel that their medical condition is putting their job at risk is your medical documentation, a certification from your medical provider that lists your work restrictions, also all correspondence with either management or HR in regard to disclosing your medical condition and your request for reasonable accommodation, or text messages. So it's the medical documentation as well as your communications with your employer that are very important in cases like this. If an employee waits too long to see if they have claims against an employer, they may be barred by certain statute of limitations. For discrimination cases under the FEHA, the Fair and Clement Housing Act in California, the statute of limitations is 3 years. However, that time can be shortened. If you are a public employee, it could be as short as 6 months. So it's important to talk to an employment law attorney as soon as you're terminated so that the facts can be assessed and the claims can be assessed to see if you have claims against that employer. In the first 48 hours after an employee has been let go, after they disclosed a serious medical condition or a physical or mental disability to their employer, is gather your documentation and start writing out your story. Start taking notes, including dates, names, what transpired, what you were requesting from the employer, what you needed, when you disclosed it. All of those details are really important to tell your story and pursue a claim against the employer when they've discriminated against you. There was a moment in my career where I was representing an employee, an excellent, stellar employee who was completely dedicated to his position of employment. And as soon as he disclosed his disability and requested reasonable accommodation for that disability, he was terminated. He was prevented from going back to work. And that moment when he finally had someone understand him and listen to him and stand up to the bully was the employer in this situation, he finally felt like he could rest, sleep at night because he had someone else fighting his battle. He tried so long to fight this battle alone. And then once we stepped in and advocated for him and we were his champion, his support system, there was nothing more rewarding than that because we validated what he felt like was happening in the workplace. We validated the fact that he felt like he was targeted and being discriminated against. He read the laws, he researched it, and he was like, no, something's wrong here. I know I'm entitled to these rights under the ADA or the FEHA, but nobody was listening until we stepped in. And he could finally sleep at night and eat and breathe because he had someone sitting next to him saying, I will fight this fight with you. I will be on this journey with you. And we're going to take it to the end. No matter what happens, we're going to tell your story. For someone who's sitting at home and they were just fired and they're dealing with a serious health scare or medical condition, I want them to know that your health is most important. Take care of yourself, get the medical care and treatment that you need. And then once you're feeling strong enough and you can gather your thoughts and your information that you need to provide to the employment law attorney, go talk to an attorney to assess your situation. But take care of your health first. That's the most important. Consultations for employees that feel like they've been terminated because of being sick or disclosing a serious medical condition or physical mental disability. Their consultations will be them coming into the office, telling their story, and understanding what their employee rights are in regard to their situation. Most consultations are free.